events, and we have most of the events in person, but this is one of the very few events we have which is virtual. And we're glad that Dr. Osgur Khan is able to join us all the way from New York. And I'll tell you more about him before we proceed. But before that, I would like to say this. So this topic actually it's on third-party funding and quantum assessment. And again, we're saying this is more like a workshop through stroke webinar because it's going to be hands-on. You'll be hearing from the leading expert. And we are not just going to discuss theories here. We're going to discuss both theories and practice because he'll be sharing his personal experience. And the title of this webinar, as you all know, is Strategic and Financial Dimensions of International Arbitration, Third-Party Funding and Quantum Assessment. And for today, we'll be focusing on Module 1. Now, we've broken this into two modules because it's so heavy, and we don't want to keep you waiting because we know the kind of the Zoom fatigue people always have. So we want to kind of make it into two different parts. For today, we're focusing on Module 1, and tomorrow, inshallah, we'll be going for Module 2. The same time, the same people, the same speaker. And I'm not going to say much because I don't want to preempt today's speaker. But of course, you all know third-party funding is extremely important and is increasingly being used in international arbitration. But apart from that, the quantum assessment for me is even more important because how do you assess damages? How do you assess multi-claims, multi-jurisdictional claims in some situations? So this is extremely important. And this is what Dr. Osgur will be breaking down for us. And he's bringing in it with a lot of experience, to discuss some of these issues. He's going to look at aspects relating to, infrastructure and construction disputes, some of the case studies will relate to the OIC countries. He's going to look at even access to justice and third-party funding. And of course, he'll be sharing a number of case studies with us. And of course, and then some of us will be kind of interested in knowing, okay, you're talking about OIC country and you're talking about third-party funding. You will also be interested in knowing, okay, what does Islamic law says? And this is where the Islamic finance dimension comes in. And it's extremely important. As international arbitrators, we have to be concerned about this because you're dealing with some OIC countries where your award may be refused enforcement just for violating public policy of a particular country. Why? Because you've not complied with the principles of Islamic law or principles of Islamic finance. So this is where it's extremely important for us to learn about this, at least learn the basic principles. You don't have to be an expert in Islamic law, Islamic finance, but this is extremely relevant to your legal practice. It's extremely relevant to your practice as an arbitrator. So this is why we are here today. So now let me introduce the main man who will be leading us. And just to let you know, I know we are live on YouTube. Basically, we'll be having a lot of humor, as we proceed. I don't believe in boring sessions, so we're gonna have a lot of humor. So kind of forgive me if you don't know you for this style. And let me introduce Dr. Osgur Khan. Dr. Osgur Khan is the Vice President in Financial Markets Practice at Charles River Associates in New York. There are a lot of rivers in New York, so. Yeah, I'm not surprised you have River in the name of your firm. Now, Dr. Osgur Khan is a distinguished testifying and consulting expert in liability and quantum of damages and a qualified arbitrator. He has provided expert reports and oral testimony in numerous cases before state and federal courts in the US and in the UK, as well as in domestic and international arbitration. Under different platforms, you can talk about ICSID, PCA, ICC, FINRA, JAMS. He's been there. He's everywhere. I know he sits here even in Istanbul. I think he's been handling some cases with his stack, and that's actually how we met, a few months ago. So he's a distinguished arbitrator, renowned globally. He has served as both co-arbitrator, of course, and sole arbitrator in multiple disputes under the ICC and STAC, and also volunteers as an arbitrator in the Ninth Judicial District of the New York State unified court system. That's a very important part. He was telling me the story about that, what they do, basically volunteering as an arbitrator. Perhaps if he has some time, he'll share those kind of experiences with you. This is someone I believe we're going to learn a lot from. We really miss him. I thought he'll be here physically, to kind of deliver this, so that he can interact with, our young professionals who are here with us today. And but again, we can still interact with you. So young professionals, you can actually ask your questions, using the chat box we have there. I think there's a Q&A box down there, so you can use that to ask us questions. Of course, I call him Dr. Khan. He has a PhD in finance. And he also has an LLM with distinction. You can imagine he has an MBA in finance, he has a BS in electrical engineering, he has a CFA and FRM designations. What else are you lacking, Dr. Khan? We are really
Uh,
privileged to have you today. And I know we
Thank
share
you.
a lot in common, even though I'm not an engineer. I'm a financial lawyer, and but I'm not an engineer. So it's really great to have you today. And we really look forward to learning a lot from you. And the format of today's webinar is this, guys. First thing, we're going to spend the next 1.5 hours listening to Dr. Osgar Khan, but do not wait for him to conclude the webinar before you ask your question. Don't wait for him.
Yep.
Throw your question there, and if I need to stop him, I'll stop him from here in Istanbul. I will say, you've got to stop there. We've got a very critical question, but you have to kind of prompt us. You ask the question, and we'll take it from there. So please use the Q&A box. I know some of you are joining from our hearing room. We have a lot of physical participants, on-site participants who are here with us in the office. Those in the hearing room, if you want to ask a question, you can also log in maybe through your phone and ask the question through your mobile so that we can actually take it from here. And without further ado, I would like to invite Dr. Khan to take the floor. Welcome.
Okay. Thank you very much, Dr. Oseni. Thanks for let me share my screen as well. Uh, we already talked about me, and as we all start our presentations, now what you see here is that I have to put my disclaimer. I don't know if you can see it. Uh, uh, the opinions and the views I express in this presentation, they are my own, and they do not represent any of the views of my colleagues in Charles River Associates, any other employee, consultant, or contractor. So thank you very much for the lovely introduction, Dr. Oseni, and I'm flattered with your introduction. And for today, I have a series of topics, but you see that these topics are not only for today. Um, we will continue tomorrow, and very likely we will continue in a personal workshop in Istanbul closer to the end of December as well. But for today, I'm going to follow these three boxes and tomorrow as well, which will be the building blocks of the two modules. Very likely today's session will be done around the middle of the box too. Access to justice and the third party funding. I may be presenting or introducing new topics to you, but please be patient. This will not be, as you see, the overall line of my presentation spread over three sessions. It will not be a linear kind of presentation. You can think of some Hollywood movies where I may leave you in suspense at one point, but eventually everything will be tied together. That will be the way I will continue with the presentation. And okay, as Dr. Oseni mentioned, I have an advanced degree in finance, but I also have a law degree. And what kind of a legally trained person, especially in a common law system in the UK, would be without presenting the list of the legal authorities? Very likely, most of the authorities, the cases will be covered in December. But even with what you see, we can we can learn even a lot from just the information on this slide. And that's what I'm going to say in terms of the typical exit cases. I really like the way they put their information in terms of when they, if you look at anything like this, like this ICSID arbitration 1421. What does it say? It was an arbitration filed into ICSID in year 2024, and the last digits are the index numbers. Every year on January 1st, they start with 1 and then incrementally they go 2, 3, 4, all the way, whatever may come end of the calendar year. So what do you see here? Even just looking at the list of legal authorities, it will be tied to the benefits of international arbitration as well. If you look at the first one, it was filed in year 1987, and the award, you can see that it was issued in June 1990. So you can say about a 3.5 year kind of judicial process from the filing of the notice of arbitration all the way through the issuance of an award. And in tomorrow's session, I will be talking about this one, the Lupaca Gold versus Peru. And you can see that this arbitration was filed in year 2020, maybe around the middle of the or the later part of the year with the index number 46. And of course, these were just the dark days of COVID pandemic. And the award was issued middle of 2025. So compared to the legal process in the courts, in international courts, domestic courts, a typical lawsuit, not an arbitration, the extent of the duration from the filing of a claim all the way through the issuance of an award, they are very respectable periods. And of course, there may be some other cases, but that's pretty much what we see, even with the information contained in my list of the legal authorities. So let's talk briefly about international commercial and investment arbitration. And maybe I should point at the distinction here too. Commercial arbitration typically refers to the arbitration between two commercial parties, while when we mention investment arbitration, that's the typical investor state arbitration in the form of an investment made into the home or country. And of course, when we come to the secondary bullet point, I will show you some statistics as well. This is the typical introduction for international arbitration. Here, I'm not making any distinction between commercial and investment disputes, but it has been the preferred mechanism to resolve all those international disputes. If you go back to maybe 150 years ago, it was more of all those resolution of the international disputes by the gunboat diplomacy. We have come a long way since the times of the gunboat diplomacy, and the international arbitration is typically preferred as the most practical dispute resolution system or mechanism. And that's why we are also having it under the umbrella of our hosts, OIC, AC. AC here stands for the Arbitration Center. And what happens here is that with this more practical dispute resolution system, the parties can resolve their disputes faster. That's why I started with my list of the legal authorities. We have a relatively reasonable time period over which these disputes are resolved. They are cheaper, but I take it with a grain of salt. Cheaper with respect to what? And in some cases, these costs can blow out of proportions. And there will be different sections, different slides over the course of my presentation when I will talk about the costs. And these costs will vary. And we will see a little bit of variability in that regard as well. And of course, confidentiality is quite important from my perspective as well. Once some kind of a dispute is submitted to the court system, typically the documents are open to the public, and the confidentiality requirements cannot be imposed in a typical court setting right away. There might be special applications to reach some kind of confidentiality or the sealing of the documents in that regard. So, why do we have international arbitration? More advantages, more advantages. We have more flexibility and control over the proceedings from either party's perspective. And the parties can definitely decide on what kind of a dispute resolution mechanism will be enacted when they go through the contracting stages. As some of you, or as most of you, are familiar with the competence principles too. Now, for the dispute resolution part, not the substantive part of the contracts, but for the dispute resolution, a certain leeway is provided to the parties over the decision makers, the arbitrators. What kind of a forum? Will it be an ad hoc arbitration, or will it be under the rules of a certain arbitral institution? What will be the substantive law of the contract versus the dispute resolution, and what will be the procedural laws or even rules? And eventually, what are we looking at? What's the whole purpose of international arbitration? There's a dispute, it needs to be resolved, and looking at the commercial and investment or the investor state perspectives, what we see here is that there is a reward, a remedy sought, typically in the form of damages. And that's really the heart of maybe the latter part of this presentation or this set of sessions. So these awards, which will be quantified, they need to be enforced. If the enforcement is not taking place, they will only be awards written on nice pieces of paper with very well reasoning in that regard. And many countries are parties, or they are signatories to the New York Convention for the recognition and the enforcement of the arbitral awards as well. And what can be the grounds for maybe failing to recognize and enforce those arbitration awards, the damages? And of course, we will talk about interest. Is it interest, or is it some other form of compensation? And in any uh, setting, if we are looking at Article 5 of the New York Convention, these awards cannot be and recognized and enforced under the circumstances of violating the domestic public policy in the enforcement jurisdiction. In my company, we have other colleagues who do the asset tracing and enforcement related activities as well. So if there is some kind of a dispute in between two entities, their contract may be subject to the law of a different jurisdiction, but the enforcement of the award can be tried to be made in a totally unrelated jurisdiction, as long as we have all the parties as signatories to the New York Convention. And this is really an interesting field in the sense that for those violation of domestic public policy, I will be touching on two principles of Islamic Sharia under riba, interest, and garar, the speculation, excessive speculation, which may form the grounds for being regarded as violating the domestic public policy of that enforcement jurisdiction. So we will come to it. Everything will fall into place slowly but surely. Let's move on. What about arbitration in the Islamic context? Given where Islam originated in the Arabian Peninsula, Islam was always a religion of trade and business. Prophet Muhammad was a merchant. And of course, even in the pre-Islamic period, a good deal of the disputes were resolved in the whole Middle East region by arbitration. Now I have it in as tahkim as well, which is a Turkish word too, but it is common across the Islamic countries as well. And what happened was that if the parties could not resolve their differences in the sense that maybe through negotiation or maybe some non-binding mediation like uh, mechanisms. I'm making reference to the current practices, but then what would happen is that the such disputes were often referred to the hakems, the arbitrators. And so it has that kind of common acceptance or the general consensus on arbitration being the preferred method of dispute resolution under the Islamic jurisprudence. So, looking at the first years of Islam, Prophet Muhammad, he resorted to tahkim in his own disputes with a Jewish tribe, Banu Qurayza tribe. So, he used it as the dispute resolution mechanism for his own disputes, but he also took over the role of the arbitrator. And before he was a prophet, and after his prophethood too, including again arbitrating such conflicts between the Arab and the Jewish tribes. So we have all that common acceptance of arbitration in our culture. And I really had to put this, the first treaty entered into by the Muslim community, the Treaty of Medina, was between Muslims, non-Muslims, and the Jews. It called for the disputes to be resolved through arbitration. So it was inscripted into the treaties about how many? 14, 1.5 millennium ago. So that was really this a good period of time for it to really disseminate through the whole Islamic culture as well. And of course, after the time of the Prophet Muhammad, it has continued to serve as the prominent method of the dispute resolution. And looking at other legal documents too, given my Turkish heritage, I had to mention the Majella of Legal Provisions, which is the first codification of the Sharia under the Ottoman Empire, and it had one section, you can say maybe one chapter dedicated to arbitration as well. So we are not talking about arbitration out of blue. It is really in our cultures, and it has been the preferred mechanism of dispute resolution, not to mention all the advantages it provides to the parties involved in any dispute as well. Now, this is the part I like the most. Now we have some numbers. These are the numbers that I gathered. They are accurate as of end of October. That's the time when I started finalizing the material in this presentation as well. What I did was to look at the disputes typically in the top international courts of arbitration under ICSID and PCA, Permanent Court of Arbitration in The Hague. ICSID, I should have introduced it for those of you who are not familiar with it. ICSID stands for International Court for the Settlement of Investment Disputes. It is headquartered in Washington, D.C., and it is one of the organizations of the World Bank. So ICSID arbitrations take place under the umbrella of the World Bank, and they are typically investor state arbitrations. Here I have looked at the claimants only from the OIC member countries. And I looked at the claimants in terms of the industry that they are operating in. That's in the sense that the industry they are operating in refers to the nature of the project, which is at the center of the dispute. And also I looked at the claimant countries. What do we see here? If we look at the industries, and given that specifically our OIC region spreading from maybe 10, spreading about maybe 8 or 10 time zones from east to west, we have a good deal of the construction projects going on, followed immediately by oil, gas, and mining disputes. The projects, at any point in time, there might be a dispute. It may not necessarily be an expropriation, but it might be, speaking of the construction projects, it might be a delay. It might be some kind of mismatch between the geological surveys and what the actual situation is on the field. Transportation is, I would say, another important one too. It's not necessarily mass transportation, but it can be shipping, ports, warehousing, or it can be some other means of transportation in the form of roads or mass transportation within the cities as well. And that's what we see. So I think I have my Excel file here. Can you see it?
Yes, we can see it here.
Okay.
Yeah.
So I put all of my data here, and of course, let me oops, make it. This is more like the pivot table where I have the claimant country against the top three industries from my perspective. Turkish companies filed 6 arbitrations under construction, and knowing Turkey, it's quite expected. Lots of construction companies,
Yeah.
Turkey-based construction companies, they bid for and got the concessions to build different, I may say, airports,
Mhm.
maybe other infrastructure facilities in the whole region, followed by UAE, and two of their matters are in construction. The other two are in oil, gas, and mining. It's quite expected. Anything you want to say, Dr. Oseni, about the
Sure.
Nigerian companies in oil, gas, and mining?
No, I don't want to talk about the P&D case because that's related to Nigeria. It's a popular case. That was a big scandal. I'm not going to talk about that, but I'll talk about Turkey here because
Okay.
we do have with us Dr. Eda, the head of international arbitration at the presidency. She's joining us here. So when you mention about Turkey, I'm sure she's actually listening carefully because she's the one
Okay.
managing. Dr. Eda is with us here. So you can
Um,
proceed.
okay, let me go ahead then. And of course, Now we are talking about everything with our eyes on the third party funding and also what may happen with the quantum of damages as well, and what might be at stake in the middle of the overall effort too. And if we are talking about those construction companies, they might still be cash strapped down the road for reverting to the international arbitration centers, wherever they might be, depending on how the contracts were written. And there may always be the need for some kind of third party funding down the road. However, you may have noticed that I skipped the finance part. Of the seven claims filed by the claimants in the finance related disputes, I'm now looking at my notes as well. I see that two of them were filed by Qatari National Bank. And I can assume that those of you in Istanbul in the room, you can see their Turkish headquarters outside your windows. That beautiful tall building. And another two were filed by the Libya Investment Authority against Belgium. So they do not necessarily, those two claimants representing four arbitrations, they do not typically fall under the auspices of what I am going to talk about afterwards. So I'm just going to skip them for the time being. Again, now we have Turkey at the top of the league with the number of the arbitrations as per my selection criteria, OIC country claimants, and followed kind of distantly by claimants from the UAE, Malaysia, and Lebanon, each with four arbitrations. Okay, so now we are just talking about all the context of the commercial and investment arbitration, the Islamic context, and the claimants. What about the third party funding? I already started with the glimpse of the third party funding in terms of the cash strapped, or maybe the claimants or the entities which may have claims, but they may not have the necessary funds. So now I'm going to move towards the third party funding as a means of access to justice for the uh, claimants or would be claimants with meritorious claims without the necessary funds to pursue their claims. Very likely they may have devoted all of their funds for their projects. I'm going to cover this maybe as the last item for today's material. Tomorrow I will start with the success story, but I may just do a few fast forwards to some other slides to point to some of the key metrics that I can tie to the need for third-party funding. So, what is third-party funding? Don't give me that it is a third party which is providing funding, but that's what the name says. And what happens is that a third-party funding is provided by a third-party funder, which is neither a party to the dispute nor the other typical parties involved in the dispute resolution, such as the lawyers, the legal counsel, and as the founder part implies, they provide the financial resources to enable the costly litigation or arbitration cases to proceed. So they enable the judicial process to move forward, given that we are talking about some resources. And another keyword here is the costly part, because we all know that there's a good deal of high rates associated with the legal counsel. There are experts like myself. There are arbitrators down the road like myself. And there are also costs associated with the institutions down the road too. And this is all assuming that there will be an award which will be enforced. And another keyword I like here is that the third-party funder does not have any pre-existing interest in the litigation or in the dispute, but as a result of the funding, they expect to be paid, or they expect to recover sums from the outcome of that dispute resolution process, either litigation or arbitration. And those recovered sums, usually a percentage, is somehow bleak and up in the air. It is typically compared to a contingency fee, which is charged by an attorney, by legal counsel on the claimant's part, if it is arbitration, or on the plaintiff's part, representing the plaintiff if it is a litigation. And that's the expected outcome. But expected based on what? That's all dependent on the outcome of the case. And the first three lines of that bullet point typically refer to an expected outcome, an award, a decision which will be enforced, and through the recovered amounts, a percentage will be paid to the funder, like a contingency fee. But at the other extreme, if the litigation or the arbitration fails, if they do not prevail throughout the whole process, then the funder is not entitled to any amount. Whatever has happened over the course of the process, that typically refers to the amount of funding that they have provided, is gone. And there will be, of course, different issues around the term what's gone. If we talk about the security for the costs in typical arbitration matters, then they might be opening the door for some further discussion about what may happen. And I threw in some third-party funding related funding that's more coming from the common law jurisprudence too. Maintenance and champerty have been all frowned upon in the common law jurisdictions. But maybe starting with the more recent experience, they have been allowed under different conditions. And we will get into the different parts of the arbitration center's rules for third-party funding related activities as well, typically in the form of disclosure. Maintenance is encouraging others to prosecute a lawsuit without a bona fide interest in the lawsuit. Then we move one level down, or we can funnel it down. In champerty, a non-interested party provides the funding in a lawsuit, in a dispute, in exchange for a financial interest, usually a portion in the proceeds. And that's what we are talking about for the typical third-party funding. Barratry is a practice which is, again, a no-no. It is frowned upon. It is, we can think of it as a continuing practice of maintenance and champerty, as the definition goes, but it's more of the meddling of or the intervention of the third party funder to the overall judicial process as well. And that's a no-no, it is frowned upon, and it might be grounds for a summary judgment or a default judgment against the party which employs a barratry practice employing third-party funder. So, what do we have from the third-party funding point of view? I know some other colleagues in the past talked about third-party funding too, but rather than talking about the advantages first, I talk about the criticism. And you can associate that looking at whoever talks about an event, they have a certain point of view. And here, from the criticism, these might be the parties who might have a different say about third-party funding because they are at the receiving end or they are the typical respondents in arbitration or defendants in litigation which are funded by third-party funding. Their criticisms include, this is not an exhaustive list, but increasing the number of cases, especially weak or frivolous lawsuits. So their point is that the judicial system is flooded and directing money away from the injured in the sense that that percentage uh, portion taken by the third party funder from the overall case proceeds is directing money away from the injured because the injured is getting the damages award. And third party funding prolongs the judicial process and increase the costs. And they also talk about discouraging the settlements or other alternative dispute resolution mechanisms. And this is the place where I will talk about the settlements too. Maybe 5 or 10 minutes ago, I talked about the case prevailing, going full course, and then award. A decision is rendered at the end, or the claimant party does not prevail, they lose everything. But in between, there's a settlement as well. And that's another likely outcome of the whole process too. Now, what about the advantages? As we are talking about the third-party funding, I am going to look at some of those success cases too. The third-party funding definitely provides access to justice for the impecunious, for those not well-funded litigants or who may run out of funds, who may have meritorious claims, and they cannot bring those claims into the proper venue for access to justice if they do not get this kind of funding from the third-party funders. And another case is that the litigation might be too costly. The arbitration might be too costly. There are some examples which will come down the road as well. And if the defendants have deep pockets, then there might be some kind of an imbalance about or in regards to the amount of funds that these two opposing parties may allocate for this process. And about 1.5 years ago, I made another presentation in New York City Bar Association. I'm part of the International Law Committee there, among other committees too. And it was a litigation which was in the Southern District of New York. That's where the financial disputes are resolved, typically in the US. And it was a litigation case against the government of Argentina, where the allegations were that the government of Argentina expropriated the rights of the shareholder rights of two separate investors in the Argentine oil company. From the court documents, what we learned is that the overall expenses, the costs of the plaintiffs amounted to some sums over 50 or 60 million dollars just for going through the overall litigation process. So if we are talking about a deep-pocketed defendant versus uh, different investors whose investments were expropriated, they would not have been able to fund such a prolonged and very document heavy, expert heavy, lawyer heavy kind of litigation in the process. And also, other advantages include the mechanism to oppose undue pressure from the deep pocket defendants to settle cheaply. So it's that kind of uh, amounts. Okay, I have a question from Dr. Oseni. Do you want to read it or should I read it?
Yeah, I can read it. It's just
Please.
related to what you were just saying just now. I just wanted to give some context to allow you to kind of, sip, some coffee or tea. I don't know what you're taking there.
Yep.
Yeah, so that's why I wanted to just cut in here, and I can see you drinking. That's fine.
Thank
The question is this: if a client and the third party funder disagree on a crucial matter, such as accepting or rejecting a settlement offer, what is the standard enforceable dispute resolution procedure used to resolve this conflict within the funding agreement? Bearing in mind that we had a similar situation in one of the English cases, because the third party funder will always want to get more because of the percentage they have agreed upon, and you see the client trying to settle for maybe something lower than
you.
what's in the agreement. So how do you kind of resolve this through an enforceable dispute resolution procedure?
At that point, if it comes to that kind of a settlement, and this is one of the big issues in the ISDS mechanism revisions under the Working Group 3 in the UNCITRAL 2, if it comes down to this decision, the third party funder should not be involved. It may be grounds for again a default judgment against the funded party, because what happens here is that it would be turning into a form of barratry in the sense that the third party funder wants more. If they are not willing to settle, they would have a direct intervention in the case. And that's the place where they should leave it to the legal counsel and the actual claimant or the plaintiff in that case. These third party funding agreements, their presence is subject to disclosure, but the judge or the arbitrators may request or may order to have the full content revealed. And in that case, it would work against them. And they are very careful not to walk down that road. And it's a very, very tricky situation in that regard.
Okay, yeah, that's quite interesting. Why I brought up this issue is this. I want to avoid a situation where we're going to have this kind of snowball effect of disputes kind of coming out of disputes. So
Yep,
you've got a third party funder supporting a particular ongoing proceeding, basically. And at the end of the day, there's a dispute between the client and a third party funder, and that dispute leads to another dispute
yep.
and keeps snowballing. How do we kind of, introduce what they call the circuit breaker at some point, to kind of stop this.
That will all be part of the actual contracting process between the third party funder and the funded party with their counsel involved as well. And anything outside those limits, they may come very close to the third rail, which means that they will get shocked. And that's why it is one of the criticisms. I know it, and but this is one of those minefields where the third party funders should not go. And as you said, they might find themselves in litigation down the road, or they may initiate it themselves too. It uh, it happens, and it would happen in the future too if we encounter such parties. But it is not really within the frame of reference for the contract drafting in between those parties. And now we talked about the costs, and more costs. And for the legal and arbitration costs, we have an average of 8 million given in certain references. Let's go to the OECD study. I will just open it on my other screen if I can. Where's my presentation here? Oops. And I will find it in the meantime. It was in footnote 23 where they mention it, or I can say that it is in the range of 8 million, but in some cases it is multiples of it, all the way up to 30 million. So this is the place where I will do a little bit of fast forwarding, if you will bear with me. This is one case which I will cover tomorrow, and I will repeat it tomorrow too. But if you look at the overall submission of the costs in the decision of this Lupaka Gold against Peru matter, you can do the addition. The claimant submission of costs was slightly over $4 million, pretty much the same for the respondent as well. So we hit that mark. It's not a bad statistic, even though it comes from an earlier study in the early 2010s from the OECD. There will be some others, and let me fast forward to. I'm not going to get into this. At some point, I will talk about the Tetian v Pakistan matter, to very likely in December. But now the costs, the claimant's total costs are over $62 million. It's at the bottom. It's in small fonts. I apologize. And the respondents, that's the government of Pakistan, about $25.5 million as well. Add them together, yeah, 87.5 million dollars. So that's what I would say. And as you saw the breakdown too, most of it is most of the costs are related to the council's fees and expenses, and that includes the experts like myself too, or the arbitrators' fees, and for the arbitral institutions too. That's why I talked about the costs taking place later on too, but now you get an
Yeah,
idea about it.
absolutely. I mean, you're saying a cost for experts like yourself. That means you've made a lot of money from that. We are live, so you don't have to say anything about that. So
No, 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 no.
let me stop
Oh,
here.
the point is that my time is charged by my company to the clients. I do not make any money.
I
They
know
go
you.
to the company.
Of course, you make money through your company here. Just joking.
Okay, so let's talk about some. Do I have anything in between? I don't think so. We talked about the. Oh, I knew that I had something, and for the access to justice and the third party funding part, and what are some of the key ingredients? And that's why we will see the other parts in relevance to the quantum of the damages as well. So what do the third party funders do? They want to find the meritorious claims. There's a reason that we have certain parts marked in bold. They seek meritorious, the cases with merits, with the claims large enough to recuperate their original investment and then to get a return on them. So you cannot talk about those large claim matters in your typical case or in mass tort cases. These larger amounts, whatever large may mean, we will talk about it too. They can come from the kind of disputes in investor state arbitration, the typical expropriation of the investment, or some kind of major delays in the construction matters, some high stakes commercial arbitration, definitely intellectual property litigation, and the securities litigation. These are the kind of disputes in which the amounts at the center for compensation to the hurt party are large, at least from the original claims point of view. The point I was talking about is that the terms of the term sheets, the financing terms in those agreements, they are typically proprietary, and they are not disclosed that much. While in the next slide, I will talk about at least the disclosure of the presence of the third party funding must be made, and in some cases, some major uh, points of those funding agreements must be made. Here is the whole heart of this set of presentations. The third-party funders conduct intensive due diligence. They do not fund each and every case that enters through the door. And they have their internal teams who do the due diligence. And they also hire third party, or they hire external uh, professionals to assist them in the due diligence as well. So they hire external law firms to assess the merits of the case. So that's on the liability side. And the resolution alternatives. So these external legal advisors, they can talk about all the positives and the negatives and the likely outcomes in terms of some probabilistic measures as well. And everything can be put in a law firm memorandum too. In the past, I also was retained in my prior career as a quantum expert to assist in the due diligence stage. Not only afterwards in the typical legal process in terms of the submission of the expert reports, but in a more quick fashion to look at the outcomes as provided by the law firm, different parameters set for the likely outcome, whatever it might be, associated with its probability, and then to the quantum of the damages calculation for those matters. However, what do we have in that regard? What do the quantum experts do? They quantify the damages. They employ different methods, and that will be the overall second half of this set of presentations in December. And we will talk about some case studies and some other examples too. And what about this part? We haven't touched on Garar, the excessive speculation under Sharia law too, but to the extent that the law firms, the plaintiffs, the third party funders, and their legal counsel rely on due diligence from external parties, external law firms too, that kind of due diligence first overcomes any asymmetry of information or among the parties. Then they can overcome any excessive speculation. And what will happen is that they will not uh, breach any garar, excessive speculation kind of limitations for their funding. Okay, why is my, yes, I'm planning to use this as the last slide of today's session. So we have quite a lot here, whether you believe it or not. So what did I talk about? The third-party funding provisions in different arbitration centers rules, or the benchmarks, or the industry practice guides as well. Where should we start? I should not follow the order, or should I start from the very top, Dr. Osene? We should definitely start from the very top.
Well, if you want to have a dinner with me when you are here in Istanbul, you should start from the top.
Okay,
Or else
definitely.
we're not gonna welcome you here.
I got the message. I got the message. And this is also part of the discussions we had a few weeks ago too. In the under the OIC arbitration rules, Article 10 7 talks about the disclosure of the third party funding, but the second part of the sentence is more important. To the best of my knowledge and to the best of what you have reflected in our discussion, there are further revisions being made for the next release of the OICAC arbitration rules. And very likely, or it's my understanding that there might be the definition of different circumstances where the sole arbitrator or the arbitral tribunal may request the details of the third party funding agreement, or even in some cases can ask for special disclosures in that regard as well. Early this year, now I'm moving to the CIR guidelines on third party funding. It was in the works, and CIR came up with the third party funding guidelines early this year. And I have another question. Oh, yeah. And it has different sections. My only criticism of it is that they do not have the table of contents up front. Apart from that, they really all the people who contributed, they have put in a good effort. And from the earlier drafts to this final version, this is a wonderful document to go through. Even though in certain sections, I think that maybe there might be room for improvement too, specifically about the due diligence part. Due diligence is dear to my heart within the scope of today's conversation, because it will help us down the road in terms of overcoming any kind of excessive speculation or gambling kind of allegation, or the quantum of damages related criticisms which have come up quite recently over the last maybe 1 or 2 months as well. I'm thinking of maybe talking about it in tomorrow's session in that regard. So this is a wonderful document for you to get acquainted as well. Now, that's next. I'm jumping to the UNCITRAL Working Group 3 on ISDS reform, and I have lots of notes from my perspective for the Working Group 3 as well. Dr. Oseni, I think he visits the Working Group 3 meetings in Vienna and in New York. I think they are every 6 months or so. Let's go there and I will walk you through that. Let me bring. This is the Working Group 3, Investor State Dispute Settlement Reform. There have been lots of criticisms about the investor state dispute resolution mechanisms, and there's why there's this need. Dr. Oseni, do you have a few things to add?
No, generally we've been involved in this discussion at the level of UNCITRAL, and it's been quite interesting in terms of looking at the perspectives of the member states. Basically, I'm talking about the host states of most of these investments. I'm talking from the perspective of ISDS. And what you see majorly is that the countries, the host states are actually protecting themselves against frivolous proceedings. And this is where they try to kind of regulate third-party funding. I mean, at a point we were having a debate at on central meetings, Working Group 3 in Vienna, and there was even a discussion to regulate it proactively to kind of introduce some disclosure provisions. Disclosures are fine, but when you actually go beyond just mere existence of the third-party funder or third-party funding agreement, you're going into the details of it. You are saying you should kind of attach the contract, basically the third party funding agreement should be submitted to the tribunal. At the point, I had to kind of raise my hand up. I raised my flag to talk, because they were all speaking from the perspective of host states of all these investments, and I just had to kind of raise my flag to say, hey guys, let's look at the perspective of the investor, the claimant in most cases. Um, and I actually had to caution them that we should be careful about the extent of regulation. Regulation is fine. Disclosure requirements are fine for third-party funding, but let's be careful so that we don't stifle all these kind of investments in your countries. People will just shy away. They will not want to come. So I had to kind of caution them by telling them that it's important to kind of recognize that even under the English law, there's privity of contract. Why should I disclose even the content of my contract? I mean, with you, basically. So we had this discussion, but what I discovered that there was a whole room, they're all host states, over 100 countries, everybody speaking in support of this. There was nobody to speak from the perspective of claimants who are usually the investors, or the investors who are usually the claimants. And that's why I had to just kind of take my flag up. I needed to kind of intervene at that point. And I just shared my comments with the member countries and I stopped there. So I think it's important to kind of be holistic in our approach. Of course, third-party funding has its demerits, it has its merits, but we have to kind of look at, like I always say, we don't have to throw the baby and the bathwater away. We have to throw the bathwater and save the baby. Yes, let's look at how we can regulate, mitigate the risk involved, and ensure that we still allow it to kind of continue. We should avoid breaching some other legal principles. That's why I had to caution them on the issues relating to privity of contract, even though here we're talking about arbitral proceedings. Thank you.
Oh, thank you. Thank you. That's exactly where I was headed to, and I'm glad you took the lead there. As you saw me, I was typing in a certain document number 172, and it was from the April 2019 meeting. No, it was from the October 2019 Vienna meeting too. And that specific document is in regards to the third party funding. Even just by looking at the document on its contents, and this is solely dedicated for the third party funding. It is talking about identified concerns and the legal framework. Let's get to the meat of the document too. And so the identified concerns in this document are in relation to the conflicts of interest of arbitrators arising out of third party funding. The question again about the influence of third party funding. Your question was different, but on the cost allocation. That's the part where I think there is still room for improvement. And that's where we have it for the security of the costs. And the criticisms also, as Dr. Oseni mentioned, on the increase of the number of cases or frivolous claims, the third-party funding on the promotion and the protection of the investments, and the imbalance, which I have hard time trying to understand it, created by the practice of third-party funding, as respondent states generally do not have access to it. Any kind of a state has the taxing authority on its citizens, and to the best of my knowledge, when I compare the sizes of those claimants against the states, the imbalance is there. And there are examples, I think, from earlier periods that some third-party funding was provided to some Latin American countries for some litigation in the context of tobacco as well. So they got some funding from philanthropists in their litigation, in the litigation of the countries against investors in the context of growing tobacco. So that's what we have. So looking at the possible reform options, you already saw the headlines, the table of contents up front too. After the definition, the first one is quite strict, prohibit. And that's truly chopping its legs off. And that's what we would see down the road, maybe diluted and mellowed a little bit too. The prohibition of the third party funding is, of course, again, it would require some kind of definitions and further clarifications. The regulation is another suggested mechanism rather than outright prohibition. And then when we look at the subsections of this, limitation of the third party funding to case of impecunious, the claimants, the ones who do not have the means, but who have meritorious claims, that's welcome. What's in B? Requiring the disclosure of the third party funding. Disclosure of the presence of funding is again fine, but as Dr. Oseni mentioned, there is a preview for the contract, and we do not want the details of the contracts to be out, at least in the open space for the other parties to see as well, which might only open further cans of worms down the road. And of course, The criticism that I agree with is in relation to the costs of the arbitration process. As you just got a glimpse of those examples, in one of them, as I showed you, both the claimant and the respondent had total costs over $4 million, totaling slightly over 8 million. The other one was much more higher, multiples of it, as we talked about it, where the claimant spent more than $60 million. Had the claimant failed in that case, the claimant I know in that case prevailed. But had they failed, what would have happened? And that's why at least the third party funding disclosure should assist the arbitral tribunals and the arbitration institutions on making sure that there will be enough security for the costs of the overall process. Now, this is my expert side and the arbitrator side speaking in both contexts. Let's come to another one, which will be part of 255. I looked at this and 255. Where is this? This is what we will cover maybe in more detail in the December session too. This is more recent from a few months ago for the calculation of the damages too. And what we see here is the typical calculation methodologies, which will be presented to you in greater detail. Now, talking about the theories of the damages, I'm just scrolling down. Don't think that I was not prepared. I really had the, I want to find the specific. What I will talk about afterwards, rather than showing my slides, this is what I want to come down to. In this more recent document, the typical valuation methods, which are commonly accepted in all dispute resolution mechanisms, they fall under three categories. The income-based approach, which will be the one which will create the most headache for us, and there will be further insights about it. Then we will talk about some market-based approach, which might be the least preferred of the three, and eventually the asset-based, cost-based approach as well. So this is it from the UNCITRAL Working Group 3 on the ISDS reform. As Dr. Hosseini mentioned, he attends regularly and presents his view on behalf of OICAC. Because I'm part of the committees in New York City Bar, we get the invitations too. Even though every year I want to join, some work-related commitments appear, and despite having my name in among the list of attendees, unfortunately I skip them every year, and I'm in the office. They're only United Nations is only 10-15 minutes walk from my office. Any specific article that you want me to click on before I finalize today's session so that
Yeah,
you can get more insights about the
absolutely.
third-party funding disclosure
Yeah.
requirements from maybe Bahrain, UAE, or the Kingdom?
Yeah, thank you, Dr. Khan. Perhaps let's look at the Saudi Arabian provision here, Article 17.6.
Okay.
Yeah, let's see what they
That's the
have.
beauty of having everything interactive with the links.
Yeah,
Okay, 17. Okay,
yeah, just about disclosure.
yep.
Okay.
It is the disclosure, and it is more like a catch-all kind of phrase.
Yeah,
Economic interest in the arbitration's outcome, including,
yeah.
if
Yeah,
you like,
I think for me, I'll just interpret this as a mere disclosure of the existence of a
yep,
third funder and an agreement, not the details of those agreements, basically. And I think what we have seen with the Ancestral Working Group 3, we do have a draft provision on third-party funding already, which has advanced beyond the initial kind of concept paper prepared at
yep,
Ancestral. And what they are looking at, it's again, I was really against data provision and I voiced out my concerns about it during the meeting. They want to kind of go into the contents of this agreement itself beyond just disclosing the existence of the agreement or the existence of a third-party funder. So going beyond that and going into the details of the agreement, basically, I feel, wow, 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 we have to look at the possibility of that. That was my concern. But it's still a draft provision. I think these are aspects that are yet to be finalized. They've requested for feedback from member states, and I think we'll be having the next meeting, I think in January or thereabout. I need to check my schedule in Vienna. Normally it's Vienna and New York. So I think it's still an ongoing discussion, and we'll be very happy to get your views about some of these draft provisions going forward, at least for us to have a common position as the OIC region. This is our
yep.
position regarding this provision. So I think this is something we can take up later.
Okay, definitely, definitely. I think we will have time to catch up on these matters when I'm in Istanbul, or inshallah, at the end of next month. And yeah, it is mid-January.
Yeah.
Yep.
Yeah.
And
So
I
the
was
we
going
have a
to go
question.
to want to, yep.
We have a question for you, and I think I know you've not concluded your presentation. And for the audience, we'll be ending this session in about 22 minutes at the top of the hour. But let's get a concluding, statement from Dr. Khan, then we can proceed to the Q&A. We do have a question waiting for you from
Okay,
Ms. Hawa. I guess she's the registrar and the head of the Nigerian Chamber of Commerce Dispute Resolution Center. She has a question for you, and I do have it here. But again, before we take that, let's have your concluding part. Then we.
okay. So that's what I have for today's materials, in the sense that I was just going to show you one more piece of information from the Uncitral webpage too. You can definitely go and take a look at, as Dr. Oseni mentioned, the submissions from each and every country as well. Again, here at the very end, I have the submission made by the government of Turkey too. Once you click on it, again, you can go for the insights coming from different countries as well, which might give you the background into their thinking and how different countries are grouped under different sections of the draft paper as well. So this is for today. Tomorrow, definitely we will start with the success story. I want to start tomorrow's materials at a high note. And for then tomorrow, we will continue with maybe more due diligence in terms of overcoming riba and garar. And riba will be more covered as we come to the latter parts of maybe the December materials as well. So I'll just leave it right here. So can I get the question, please?
Sure. Before then, I'll just want to tell the audience, because you've been referencing something. Of course, we have a session tomorrow. We're going to continue from where we stopped today, where we'll be discussing, the remaining part of your presentation, including the success stories, regarding third-party funding, as well as quantum assessment. I know you'll be kind of going deep into some of this analysis, and it's really, really important. As a financial lawyer, I can appreciate this when I sit as an arbitrator, when we come to assessing the quantum of damages, there are different methods of doing this. So it's good for every young lawyer to learn all this. It's going to be very helpful. So please ensure you stay tuned tomorrow. Join us at the same time at 2 p.m. Istanbul time, so that we can actually go through all these. These are really, really important aspects for arbitrators and aspiring arbitrators. Now, he has been mentioning December. We want to have a workshop. Here we are having a webinar, so we cannot really go deep into some of the specific aspects. Now, we want to have a physical workshop in December, hopefully late December in Istanbul, and Dr. Ozgur Khan will be here physically. And again, that will be limited. We don't want a crowd. We want quality rather than quantity. He will be here to kind of handhold you guys, to kind of guide you on how to do things, how to kind of do these assessments, and he's going to share his experience through some of the past kind of proceedings, he has been involved in. So that will be a workshop. So we're going to have a deep dive into these issues we are discussing today and tomorrow. Now, thank you, Dr. Osgur Khan. I think this kind of background, information is really helpful to all of us. And I like the dimension of UNCITRAL for the listeners to know that we have ongoing reforms basically at the international level. And I'm always happy to say that the OIC Arbitration Center is involved in those discussions and will keep engaging, even though it's quite expensive sometimes to fly to New York and Geneva. But we have to be involved in some of this discussion. This is the expectation from our board of directors and our board of trustees. They want us to have a say on the table, and we have to be there to speak on behalf of 57 member countries. Now, I'd like to proceed to the question we have. We only have
Please.
a question here for now. And please, sir, for those listening, if you have any question, feel free to kind of use the Q&A tab. For those who are in the hearing room, who are attending in person in our hearing room here at the OIC Arbitration Center, you can send your questions to my colleague Marve. She's there in the room. She can actually send a question to me on WhatsApp, and I'm going to read it out here. Now, the question we have from Ms. Howard is that she said, this is according to her, I didn't quite get the explanation or how third-party funding can be structured to avoid gharar, that's uncertainty,
Yep.
and riba, interest, while still remaining commercially viable in Islamic arbitration. You want
Okay. Um, I will go first. It might be a little bit, I may have jumped the gun as well. It is a part of the due diligence process because this is spoiler alert for tomorrow.
Yeah,
And
you're right. Let me just add to this
yep,
quickly. I want you to answer this. I like her question, and I'm gonna add to
yep,
that. During our last event at the Riyadh International Disputes Week in Riyadh, that was in February, we had a session, and this question came up. And we've been told perhaps we need to provide a kind of guide. Perhaps we need to build on what you have in Chartered Institute of Arbitration, the CIAB guideline you
yep.
told us earlier, to kind of look at these are the guidelines applicable to Islamic arbitration if you like to kind of do it. And I think this is something we should take up at the OIC level. It's very important because
Yep.
someone was asking at that time. I remember we got a question from the audience that whether we have templates for Sharia compliant third party funding agreements. That was quite interesting. Yeah, absolutely. And I told myself, Omar, oh, you've got to do this. You have to do it for these OIC countries. But we've not been able to do that. But I think it's something we should do. Let me get your thoughts on this and the question from her. Thank you.
Okay. Oh, That's again coming to the definition of garar. The speculation, gambling, and excessive risk taking. So what's happening here is that again, this is tomorrow's material, but I was just trying to make my way into it. It is if a third party funder throws money into each and every opportunity knocking on its door, then it would be speculation in the sense that what the Americans call as the shotgun approach. Let's see what we can catch or what we can shoot. However, the funders' finances, their funds are limited, and they are trying to optimize their overall return on their investments across the opportunities provided to them. So, what would happen is that, as I told you, there are three possible outcomes. The claimant may prevail, and there might be a very favorable award. The claimant may not prevail, they may lose. Then the funder will lose all of the funds it provided, or somewhere in between, there might be a settlement. And we do not know what the eventual measure of the awards will be as well. I will show you some statistics tomorrow too. If the claimant comes with, I like those index numbers, 100 kind of a claim for damages, 100 as an index number, what would the respondent come up with for the damages based on their calculations? You can expect it to be, the statistics tell us that the respondents' damages calculations are typically lower, and the tribunal may decide anywhere over a big spectrum from 100% of the claimed amount to nothing at all. Or it might be a prevailing of the claimant with zero damages as well. It is possible. So in that case, the third party funder will be refraining from any kind of gambling, any kind of speculation, because it's the investors' money, the investors into the third party funder, that's money which is being channeled to the claimants with meritorious claims. So the uncertainty is reduced. You can never eliminate uncertainty, but it is reduced by by doing the due diligence properly in-house by the third party founder, by their own internal analysts, but by also the external law firms on the merits and the external quantum damages experts who would do all those calculations for the typical outcomes based on the probable outcomes identified by the external law firms. So what happens in that case is that you reduce uncertainty, and given that it's also one of the criticisms of ISDS on third-party funding too, ISDS reform on third-party funding too, is there too much of disclosure of confidential information from the claimant to the third-party funders as well, because now they are truly, by definition, the third party. They are not counsel, they are not the claimant, but a third party. With the reduction of uncertainty, which you can also say as the elimination of asymmetric information, where the claimant provides full disclosure about the merits of the claim, how the dispute came about, what their position is, what kind of documentation is likely to be provided in the form of evidence in the arbitral proceedings too, that would all reduce the uncertainty, totally eliminate asymmetric information, at least in between the claimant and the third party funder who has to make an informed decision in that regard. That's the reduction in that conditions of set of conditions of Garar. And last thing again, this was going to be tomorrow's material, but I will repeat it tomorrow too. That's why the third party funders do not fund all the requests they get. According to statistics from one source, these are the first two sub bullets, which I called as GAO. This is the Government Accountability Office of the US, which did that study maybe 2 years ago. In one statistic from two funders, they say that these funders fund or end up in agreements about 5% of the cases. So, what does it mean? 1 out of 20 requests end up in agreements. Agreements of what do I mean by agreement? Third party funding agreement. In another one, a publicly traded funder, and many people can guess which one it is in the United States because there's only one publicly traded funder whose stock is traded in New York Stock Exchange. That publicly traded funder reported that only 4% of the requests resulted in funding agreements. So that's 1 out of 25. So what does it say? It says that in the form of due diligence, these funders do their homework. They spend a good deal of time on studying the merits, the likely outcomes, and then they assess what the damages claim might be out of those possible scenarios as well. Another source is a paper written by a friend of mine here in New York City, Mohammed Swaifi. He's a practicing attorney in arbitration and litigation too, and he's also a law professor in, I think, Fordham Law School. He wrote a paper too, and in one of the footnotes or in the text of his paper, he cited 1 out of 10 requests were funded after due diligence. So all those three statistics tell you that the third-party funders do not throw the money around; they do their homework.
Yeah, that's quite interesting, people talk about third-party funding everywhere, and they're looking at the stats now, talking about, about 5% of total requests end up in final agreements. That's quite interesting. This is
Yep.
mind-boggling for me, generally. So, yeah, I know there are a lot of factors involved. You have to kind of look at even enforceability of the award.
Yep.
And so particularly if it's multi-jurisdictional, you have to look at the jurisdiction involved and ability, not only the possibility, ability to enforce the award. So there are a lot of factors involved in decision making. So thank you very much for sharing all these insights. And I'm just waiting.
My
We
pleasure.
have any other question? Perhaps they will keep their questions for tomorrow, because tomorrow I think we'll be going into more of calculations, how to kind of go into the analysis, and I think that will actually take some time. And I'd like to thank everybody for your coming, and thank Dr. Khan, for joining us, even though it's early morning there in the US. I think he was joining us at about 6 a.m. When we started. So thank you for joining us, and we really look forward to having you again tomorrow. For those of you who are here online and those who are joining us physically at the hearing room of the OIC Arbitration Center, please try to join us tomorrow. The students who came from Ankara, they are with us in the hearing room. Also try to log in from Ankara tomorrow. So tomorrow will be fully online. I'm not so sure whether it's going to be hybrid. So please, let's actually make it a day tomorrow. This is a topic that most lawyers actually run away from. And I can see even from those joining us virtually, there are some very senior lawyers here because this is something we encounter every day when we are kind of writing awards, particularly when you're getting to
Yeah.
the closing of, of submissions. This is something that you will have to deal with ultimately as an arbitrator. So
Yep.
also as a party representative, you have to know all the calculations, how to determine the different assessment, when it comes to quantum assessments. And of course, if you need funding for your client, where to go and where not to go.
Okay.
And I think this is very important. So we are providing to you a rare opportunity to kind of have, a global expert here with us today. So if you have more questions, please prepare them for tomorrow. We'll be very happy to even start with Q&A tomorrow if you have
Yep.
them with us. And if you like, you can even send the questions overnight to my team. We have the training at oicac.org. I'm sure most of you have our official emails. You can even send to info@oicac.org or even legal@oicac.org. Let's have the questions come in. We can start with the Q&A session tomorrow. And once again, I would like to thank Dr. Osgur Khan. Of course, thank those of you joining us online and my beloved students who came all the way from Ankara also who are with us physically and some other lawyers who joined us at the hearing room here physically. I'd like to thank you all and we will continue with our events tomorrow, the OIC ADR week. Tomorrow morning, we actually have a physical event, though it's invitation only event. So it's a roundtable, a high level roundtable on mediation. I will be focusing on Singapore Convention on mediation as well in terms of enforcement. We want to kind of create a situation where we have this kind of high level discussion that will lead to a policy document to be shared with the OIC member countries. So we are walking the talk. We are not just talking, we want to walk the talk. Whatever we are doing here, we want to share our expertise with the OIC member states. And this is what we're doing. So the high level roundtable tomorrow, it's going to happen here at the OIC Arbitration Center, and it's limited to about 20 people. And many of them have are flying in already from different parts of the world. And we are really excited by this. And of course, for those joining us online, on Thursday, we have the Global Arbitration Review, the GAR Arbitration Review ISDS workshop. That's a focused kind of workshop. I told everybody it's going to be hands-on different aspects, and it's going to be a whole day event at Radisson Blue Hotel here in Istanbul. For those of you who are yet to register, you can still register. I'm sure I can use my veto powers, as I always say, to admit you even for free because you're supposed to pay. If you are not an in-house counsel or a government lawyer, you have to pay. But if you are in-house counsel, government lawyer is free for you to attend. But for those of you who would like to attend, you can reach out to my team. We can actually waive the fee for you to attend. And it's going to be a whole day. Again, we have leading professionals from all over the world flying in from London, from Abu Dhabi, name it. Everybody is coming. They will all be here in Istanbul. And of course, on Friday, we have the first OIC forum for arbitration centers. Many of them are already arriving from different parts of the world, where we're going to have a closed door session in the morning. And that session will actually be limited to the OIC arbitration centers. We'll have a stack, of course, here, Itotam, we have Tobuyum, I mean, those that are Turkish. Then we have others from all over the OIC member states. We'll be meeting in a closed door session and we'll be establishing a federation of OIC arbitration centers, a formal body, and we'll be holding annual forums. So once we are done with that, in the afternoon, we'll have the open session, which is open to the public. So you can all come to join us. You can register and come here physically. That session will start with a keynote speech by the global president of the Chartered Institute of Arbitrators, Professor Mohammed Abdul Wahab, and he will be speaking and for 1 hour. And after that, we'll have a panel session to be chaired by Dr. Imad Hussein from Abu Dhabi, who is the vice president of the International Court of Arbitration of the OIC Arbitration Center. And we'll be having panelists from different arbitration centers across all the four corners of the world. And it's going to be very interesting. So it's an open session. So join us at 2 p.m. tomorrow. No, sorry, on Friday. at the TOBB Plaza here in Istanbul. We'll be very happy to welcome you all. Once again, I would like to thank Dr. Ken and thank everybody who has joined us today. Of course, I would like to thank my team who are working behind the scene, trying to make sure everything goes on well. I thank you very much for your contributions and hope to see you tomorrow, inshallah. Wassalamu alaikum wa rahmatullahi wa barakatuh. Bye.